In the previous video, we have discussed Section 54 of the Transfer of Property Act 1882, which deals with sales of immovable property. In this video, we are going to discuss mortgage and its different type. So let's start the video. Mortgage. Section 58 of the Transfer of Property Act defines mortgage as a mortgage is the transfer of an interest in specific immovable property for the purpose of securing the payment of money advanced or to be advanced by way of loan, an existing or future debt, or the performance of an engagement which may give rise to a pecuniary liability. The transferor is called a mortgagor, the transferee a mortgagee. The principal money and interest of which payment is secured for the time being are called the mortgage money, and the instrument which the transfer is effected is called a mortgage deed. When a person lends money to another, he may be content to make the loan simply on the borrower's promise to repayment of the money. In the former case, the lender has a right to sue for the money if it is not paid. But if the borrower becomes insolvent, the lender may lose part or all of his money. But if some security or value is given for the repayment of the loan, the lender is protected even if the borrower becomes insolvent. For he can always realize his money from the property given by way of security. Thus, the essential nature of a mortgage is that it is a transfer of an interest in specific immovable property to the lender called the mortgagee. The mortgage is simply the transfer of an interest in the property mortgaged. It is not the transfer of absolute interest in the property. The purpose of the transfer of an interest in the mortgage property is to secure the payment of a loan. The word transfer of an interest signifies that the interest which passes to the mortgagee is not ownership or dominion, which, notwithstanding the mortgage, resides in the mortgagor. The right of the mortgagor is only an accessory right, which is intended merely to secure the due payment of the debt. Further, the word transfer of an interest stands in contrast with the word transfer of ownership, occurring in Section 54 in the definition of sale. In a sale, all the rights of ownership which the seller has passes to the buyer. In a mortgage, there is a transfer of some interest only, and not a transfer of the whole interest of the mortgagor. Essential ingredients of mortgage. Number 1, transfer of an interest. Number 2, in specific immovable property. Number 3, for the purpose of securing a debt or other obligation which may result in a pecuniary liability. Kinds of mortgage. Following are the kinds of mortgage. Number 1, simple mortgage, where without delivering possession of the mortgage property, the mortgagor binds himself personally to pay the mortgage money and agrees, expressly or impliedly, that in the event of his failing to pay according to his contract, the mortgagee shall have a right to cause the mortgage property to be sold and the proceeds of sale to be applied, so far as may be necessary in payment of the mortgage money. The transaction is called a simple mortgage, and the mortgagee a simple mortgagee. Characteristics of simple mortgage. Number 1, personal obligation, express or implied, to pay the mortgage money. Number 2, the power, express or implied, to cause the property to be sold through the intervention of the court in the event of non-payment. Mortgage by conditional sale. The mortgagor ostensibly sells the mortgage property on condition, number A, that the sale shall become absolute on default of payment of mortgage money on a certain date. Number B, that the sale shall become void on such payment being made. Or number C, that the buyer shall transfer the property to the seller on such payment. Characteristics of mortgage by conditional sale. The essential characteristics of this form of mortgage is that in default of payment, the transaction is closed and the mortgage security become the absolute property of the mortgagee. The mortgagor, however, still retains his right of redemption, which is only lost by decree of foreclosure. There is no personal liability on the part of the mortgagor to repay the debt, unless, of course, such a stipulation can be discovered in the deed itself. Usufructuary mortgage, where the mortgagor delivers possession expressly or by implication, binds himself to deliver possession of the mortgage property to the mortgagee and authorizes him to retain such possession until payment of the mortgage money and to receive the rents and profit acquiring from the property or any part of such rents and profit and to appropriate the same in lieu of interest or in payment of the mortgage money or partly in lieu of interest or partly on payment of the mortgage money. The transaction is usufructuary mortgage and the mortgagee usufructuary mortgagee. Characteristics of usufructuary mortgage. In usufructuary mortgage, the mortgagee is placed in possession and has a right to enjoy the rents and profit until the debt is paid. It is not necessary that the mortgagee should take physical possession, for the mortgagor may continue in possession as lessee of the mortgagee, or he may direct the tenant to pay rent to the mortgagee. But unless there is a clause providing for the mortgagee going in possession, there cannot, of course, be a usufructuary mortgage. Number 4. English mortgage, where the mortgagor binds himself to repay the mortgage money on a certain date and transfers the mortgage property absolutely to the mortgagee, but subject to a proviso that he will retransfer it to the mortgagor upon payment of the mortgage money as agreed. The transaction is called English mortgage. Ingredients of English mortgage. Number 1. There is absolute transfer of property to the mortgagee, that is, there is delivery of possession. Number 2. There is a personal covenant to pay the amount. The mortgagor bids himself to repay the mortgage money on a certain date. Number 3. The property is transferred on the condition that the mortgagee will retransfer it to the mortgagor on the payment of the mortgage money. Characteristics of English mortgage. In an English mortgage, the personal debt remains, and notwithstanding the conveyance, the debtor is personally liable for the debt. Such a mortgage includes a personal covenant to which is generally annexed a power of sale. The mortgagee acquires the right to take possession as soon as the mortgage is executed, whether a right of entry is expressly covenanted for or not. If the mortgagee allows the mortgagor to remain in possession, the latter is at law merely a tenant, in sufferance liable to be ejected at any time. Number 5. Mortgage by deposit of title deeds, where a person in any of the following towns, namely the towns of Calcutta, Madras and Bombay, and in any other towns which the state government concerned may, by notification in the official gazette, specifically in this behalf, delivers to a creditor or his agent documents of title to immovable property with intent to create a security thereon. The transaction is called a mortgage by deposit of title deeds. Following are the essentials and characteristics of a mortgage by deposit of title deed. Number 1. There must be a debt. Number 2. There must be a deposit of title deeds. Number 3. The debt must be secured by deposit of title deeds. Number 6. Anomalous mortgage. A mortgage which is not a simple mortgage, a mortgage by conditional sale, usufructory mortgage, an English mortgage, or a mortgage by deposit of title deed within the meaning of this section is called anomalous mortgage. Characteristics of anomalous mortgage. An anomalous mortgage includes a simple mortgage, usufructory mortgage, that is a combination of a simple mortgage and a usufructory mortgage, a mortgage usufructory by conditional sale, that is a combination of usufructory mortgage and a mortgage by conditional sale. Example of anomalous mortgage. The mortgagor had borrowed ₹1,000 from the mortgagee and the possession of the building was handed over to the mortgagor. The mortgage money was to be repaid within a period of 6 months, and in case of default, the mortgagee had the right to bring the property to sale and realize the amount. The document, therefore, which was described as usufructory mortgage, was held to be anomalous mortgage and not usufructory mortgage, as it had character of a simple mortgage. To as mortgagee was given the right to sell the property to realize the mortgage amount.